Hi, everyone. My name is Olta Andoni. I'm Deputy GC of Ava Labs, which is a Layer 1 protocol and the fastest smart contract platform in the blockchain industry. We have a great panel here today. I'm very excited to have all these amazing attorneys with me. We do have a lot of legal topics to discuss. We only have 25 minutes, so let's start with some introductions here.
Hi, I'm Steve Wink at Latham & Watkins, and I co-chair our global digital asset and Web3 group.
Hi, everyone. I'm Brett Kaminsky. I'm a music lawyer. I practice here in New York. I represent artists, writers, producers. I'm also focused on Web3 and NFT projects that artists are releasing, and I'm working with Water and Music to work on a music NFT contract template that recording artists can use to sort of increase the legal understanding between buyers and sellers when they transact in the NFT space.
So I'm Mark Radcliffe. I'm a partner at DLA Piper, which is a global law firm with offices in 40 countries. And I'm one of the co-chairs of our blockchain digital asset practice. And I've been focusing on NFTs for about the last year.
Hi, my name is Cohen. I'm a co-founder of DLX Law, and we do work in this space.
Thank you, gentlemen. So NFTs are still in full cycle, but they have been going through their ups and downs market-wise. What are some legal issues that you think are different from last year? Or what is the trend of legal issues that we are seeing in the space this year, Mark?
Well, I think as people have indicated before, I mean, this is a young space. There are a lot of open issues, a lot of unknowns. Even something as simple as which laws apply is a critical one. So as you know, some of the early panels mentioned, copyright and trademark pretty much clearly apply. One area that people don't think about a lot is what's called Article 2 of the Uniform Commercial Code, which deals with transactions goods. And you've probably seen it, although you didn't recognize it, because all of those software contracts that have those disclaimers in caps that talk about merchantability and fitness for a particular purpose actually come out of the Uniform Commercial Code. So one of the interesting issues here, I think, is how does that apply to NFTs? And the reason that's interesting is, for example, there was a lot of discussion about, you know, Seth Green's Bored Ape and being stolen and stuff. And the question is, did the person that bought it from the thief get good title? And if you look at the UCC, the answer is no, he didn't, because thieves can't give good title, although different lawyers had different views.
Brett?
Thanks. Yeah, so from a copyright standpoint, I think what you're seeing a lot of changing is the education, again, from buyer and seller. What are you really acquiring when you purchase an NFT? And as a musician, what are you really selling when you sell NFTs to your fans? I think you're seeing a lot more focus on that discussion. People don't always understand that typically a music NFT is not a copyright. It is not the exclusive right to then go put that music in a film or to do other things with the art associated with that NFT. And increasing that understanding and letting people really focus on the limited non-commercial license aspect of an NFT and still providing utility when you make NFTs as an artist. I think that conversation has really progressed in the last year, and our work with Water and Music has been about that.
Thank you. The SEC recently, I think it was March of this year, they announced that they are investigating creators and some NFT platforms for possible violations of securities law. What should we expect from this investigation, Stephen?
Well, yeah, I mean, we do know that there's a number of subpoenas out there currently with various NFT projects. And, you know, and to level set a little bit, you know, a classic NFT that is, you know, fully functional for its intended purpose, like, you know, you buy a noun, you know, there's no further expectation of profit around that noun when you buy it. It's fully made. You're not looking at some future activity that is promised, you know, so that shouldn't be a security. That sort of expectation of profit element comes from the Howey test. And, you know, if you're not creating that expectation, then you're, you know, it's not, that shouldn't be a security. You know, but there are a lot of tangential structures around these, you know, these projects. You know, we worked with chain smokers on a drop of NFTs to their, you know, their fan base that gave some small amount of royalties to, for certain songs. And, the concern around those, as you've heard earlier today, about, potential dividend-like things. But I think you can convey royalty rights, and, and that should be workable and not make it a security. And then, of course, a lot of these projects also have a fungible token related to them as well, kind of to access and for payments and, in the metaverse. So, and of course, that brings you into that whole fungible token realm of, whether is it a security or is it, a stable coin, or is it fully decentralized or sufficiently decentralized by, with the organization of a DAO. So those are the sorts of things I think they're looking at. I think it's still early stages to know, just how concerned we should all be about this.
Louis?
Yeah, I'd agree, Steve, with what you said. I kind of look at NFTs as an opportunity and a risk. It's an opportunity to do something really new and interesting in the design space, but it's a risk if we revisit some of the lessons not fully learned in the ICO boom of 2017. And when you look out across the NFT spectrum, people are struggling to deliver meaningful value and meaningful community, and therefore are sort of pitching financialization in the opportunity to make money. It's important to bear in mind, and this is just really elaborating what Steve said, the securities laws don't necessarily treat the NFT as a security, but the scheme in which the NFT is sold could well fall within the SEC's jurisdiction. And so you have to ask yourself, if you're developing an NFT product or project, are your customers, are your users, are your community, do they really want this for its intrinsic value, or are they looking for number go up? And you should be concerned if, primarily you're marketing this as an opportunity for number go up.
And thank you. About fractionalization, I know that you are very vocal about this topic in the space. What do you think are the risks associated with fractionalization?
It's been touched on before, and I think it's great to hear different lawyers come at these things different ways. It really, from the regulatory point of view, the question is the person putting money into a project, do they have a genuinely consumptive interest? That is to say, whether it's a pair of sneakers or a song or whatever it may be, do they want it for its intrinsic nature? I love the picture of the Bored Ape and I want to own it. Or are they buying it simply to see for a profit motive as an investment? When something is fractionalized, regulators have looked at this long before NFTs and have generally said, once you divide something up, it's very difficult to have any consumptive interest. And as a result, you very likely are making an investment, and most of those transactions are absolutely going to be considered securities transactions. And if they're pitched to retail and they're not registered with the SEC, there could be some pretty serious consequences.
If I could just add, one thing that's become somewhat popular are these sort of investment club-like structures, maybe to pool their monies to buy an NFT or something, like the Nouns Party was one of them. And I think, the idea there is that, because in the investment club context, everybody's doing their own investing, nobody's supposed to be doing it on their behalf, that there isn't that sort of passive, it's not a passive investment. So it requires your active participation in the DAO. And the thing, of course, we get worried about is that, well, really, maybe if there's really one or two people that are really coordinating and doing the, really making the investment decisions, well, then that could cause those interests in that DAO to be considered a security. It could be an investment company, potentially. So that's one of the things that maybe it can work if it's done well, but there's just certainly some risk.
Mark, I know that you've been working with many entertainment clients. What do you think are the 3 or more business issues that this project should consider?
Thanks. Well, I'll try to keep it to 3. And for those of you who are sticking around, at 11:25, I'll be discussing this in a little bit more detail, and I'll also discuss why NFTs are the legal equivalent of a platypus, which is an Australian mammal which basically gives birth through eggs. It has a duck bill, it has a beaver tail, it has a otter claws, and it has a poison claw. And the poison claw is securities law. But to go to the three major issues. So the first thing is, I think every company, not just entertainment companies, but every company that is consumer facing needs to have an NFT strategy. And that NFT strategy is probably going to change over time. So you need to try things out and see what works. And you need to be sensitive to the community. There was, an example, the film company that did the latest Dune movie was going to do a series of NFTs on the Ethereum blockchain. Well, those of you who know Dune know that it's it's all about a planet that had very serious ecological problems. So the idea you'd use a proof of work blockchain to do the NFTs was anathema to the customer base, and they actually dropped the project. But so that's one thing. Number two is you need to make sure that you have the rights, because if you take a look at the agreements, particularly in the entertainment world, it's very complex as to who has what rights. And this is not a new issue. I mean, there's been a whole series of transitions with new technologies. You went from silent films to talkies to video to streaming. And each time you had one of those changes, people had to look at their agreement and see, well, is this part of it or is this not part of it? And just to give an example, Quentin Tarantino is fighting with Miramax over whether or not he can make NFTs from scripts, from Pulp Fiction. So we're already seeing that question. And I guess the last issue is that you need to be, you need to spend time looking at what's happening in the space, because there are a lot of people who just don't understand that they can't just use other people's IP. There's a pretty good example that was mentioned earlier about the Spice DAO that bought a Jodorowsky script book and thought they were going to make movies and films and television programs about Dune, and they couldn't even make it using the book, because what they got is they got the book, they didn't get the intellectual property rights. But because of that lack of knowledge, if you're somebody with intellectual property rights, you need to keep watching what's happening on the platform. And sadly, there are a not insignificant number of people who really don't care. They just want to make money, and so they'll use anybody's IP and just and so you have to be tracking this. So those are the three.
Brett?
Just to follow up on that, I think from an artist, musician standpoint, when you are selling a music NFT, since you're not usually selling the actual copyright for the reasons we just spoke about, it's not an exclusive right. You want to think about, what are you really offering your fans? What sort of utility is in that NFT? Is it a slice of a revenue stream from a Spotify sale? Is it access to a private concert or some sort of meet and greet? Is it access to merchandise? Is it the ability to remix and splice the music in other places that only you have access to as the buyer? There's a lot of really cool things happening now that go beyond just the copyright question, because the NFT sale is not really a vehicle for copyright transfer, but that doesn't mean it's not a vehicle for important fan engagement and important interaction between artist and fan. And I try to encourage my artist clients to think about that when they're considering an NFT project. What can they pack into this NFT legally that the buyer will understand, that has real value, and that makes this something worthwhile? So.
When I was here last year, and I'm sure I'm not the only one that predicted that we're going to see so many litigation cases, but we have seen so many litigation cases regarding NFTs in 2022. What are some litigation cases that you'd like for our listeners to kind of pay attention to that maybe are going to change our space somehow? Stephen?
Well, I mean, there's a few things out there. There's an interesting case involving a DAO that the class action has been filed. I mean, it'd be very interesting to see how that unfolds. And there's some concern that it's maybe a not terribly sophisticated group, and I think there's some of our clients are considering submitting an amicus brief to the court if that moves forward, to make sure we don't get some bad law created here. But the concern is that if you have a DAO, is it a general partnership, which means that everybody is jointly and severally liable. That means if you're a member of the DAO, you hold a governance token in that DAO, then you are liable for everything else everybody else does in that DAO. And so that's, that's a huge concern, obviously, and there are real issues around trying to limit that liability potentially, but that's certainly one that comes to mind. I don't know if other people have concerns.
Excuse me, Steve. Yeah, no, it's certainly, I mean, it's been touched on a number of the panels, and we're not primarily focused on DAOs, but you're absolutely right. But it is important to bear in mind that the flip side of that is if you create what is sometimes referred to as a legal wrapper, that is give the DAO token holder effectively an ownership interest in an explicit company, that could very likely become a security, and so you're out of the sort of frying pan of potential liability as a partnership and into the fire of just having an illegal securities offering. So, I mean, it's an area where you want to proceed carefully for sure.
Yeah, and there are a number of other cases ongoing, particularly it seems that LA seems to be a magnet for these, about people getting together to do a project, they have a falling out. The question is who owns the project, and that's proceeding forward. There's actually two separate cases going forward on that, and then there's the Nike case. We actually represent Nike in that, so I can't speak about that, but that's the virtual sneaker case. So, and there's the Meta Birkins case. So, can an artist take, the Birkins handbag and, basically create an NFT around it and use the term Meta Birkins. So there's litigation ongoing. I think there's going to be more, sadly, but that's the way the law gets codified.
From the music standpoint, real quick, there was that one example recently. I'm actually blanking on the name, but one company took it upon themselves to essentially create music NFTs completely unauthorized from every big name in the industry. Within 24 hours, the site was shut down, but the uproar it created was a pretty good example of how far we have to go in terms of people really understanding this and the legal issues that are involved. It was incredibly easy for a lot of fraudulent music NFTs to be created just like that. So,
we also have seen NFTs being used in DeFi, decentralized finance. Stephen, any concerns from a security standpoint, having NFTs being used in DeFi?
Yeah, I mean, there's certainly a lot of risk there, but we've seen the SEC be so aggressive in this whole space. Things that I thought were pretty clearly not securities offerings. They've been aggressive and said, no, we think they are. So, I do get very nervous when folks, create these sort of DeFi platforms for NFTs, because it's saying, okay, well, we're going to use these as financial instruments, and then there's that potentially that expectation of profit element that I mentioned before in the Howey test could be met through somebody saying, oh, if I can use this in DeFi to obtain yield, to do other things that could create that expectation of profit. So that's part of the concern I have, and just I think it would call attention to the regulators around the world, not just in the U.S. but around the world, to say, okay, well, these really aren't the collectibles that they're purported to be. These are financial instruments, and they need to be regulated as such.
Louis?
Yeah, again, I would pick up on that, and I really want to come back to the design space that NFTs offer. And I know you get panels of lawyers, and it gets like, oh my God, we can't do anything, and this is all, horrible. Really, this is an area for the creators and the community to develop stuff. One project I'd call out that's sort of the opposite of what Steve was saying is something called the Storyverse, which allows you to take PFP-style NFTs, create characters, and then have them interact with each other in little stories that can be then, displayed in video. And it's a completely new and different design space where instead of just using your PFP, in your Twitter profile or what have you, you can kind of animate them and put them into stories. Things like that are going to, I think regulators and securities, issues are going to be much less concerned because they're saying, wow, there's a clear creative thing going on here. And I really just encourage people across music and these other fields to think creatively, create genuine engagement, and you're going to reduce your regulatory risk while you're doing that. I mean, not to zero, but, you want, that's a best way to move forward.
Yeah, and I think that point is a very good one, which is, look, there is a lot of uncertainty here. You've got to decide what your appetite for risk is. Are you willing to take a higher risk or a lower risk. You know, that is something, if you're a large company, I've actually talked with somebody that was doing NFT, says, well, we don't want to take any regulatory risk involving securities. Publicly traded company, you can understand that. You know, if you're a startup, maybe you're willing to take more risk. But understand you're highly unlikely, because of the state of the industry, to get a completely clear answer. And so you need to decide what your appetite for risk is, I guess I would say. And, you know, in what Louis mentioned, I think there is some really, really fascinating opportunities here. I'm working with a group called Block of Horror that are just going to use NFTs to develop a community. The community is going to have input on feature films that are in the horror genre, because that's a very big genre. And they've already got a theater in the metaverse and stuff. So that is an example of something where, you know, and we're carefully thinking through how much risk we want to accept, you know, where, you know, I think the regulators, particularly the securities regulators, are going to be much less concerned.
Any final remarks for our listeners here from a regulatory perspective? Do you have any predictions for this year, Steve?
Well, I think it's probably unlikely, but I certainly hope that the Loomis-Gillibrand bill gets some traction and, you know, would be passed. I think it would be, actually, I think it would be an enormous boon to the economy, you know, in helping avoid a recession, because I think there's a lot of folks that, there's a lot of money on the sidelines, and a lot of folks that are, you know, are really dying to have, you know, some certainty out there in this space, you know, to continue to build and build aggressively. And so, you know, that's my optimistic hope. You know, I think it's always tough in an election cycle year to get bipartisan legislation passed, but you know, maybe some of the recent events will give both parties some reason to have something to be able to point to. So, but again, as was said in the last panel, you know, really encourage folks to support this effort, and you know, and see if we can get something passed to help out the industry.
Louis?
And I would just to add to that specifically, there's probably fewer people here from the state of Wyoming, but there's probably a lot of people here from the state of New York, and Kirsten Gillibrand is your senator if you're from New York, and you can just get in touch with her office, send an email, so happy you did this, really supportive. Those things make a huge difference. Just a handful of constituents reaching out to the senator's office, just send an email. You know, thank you. It makes a difference.
And Louis is too polite to say this, but he was actually very involved in drafting the bill. He's given a lot of thought to this issue, and I you know, agree with Steve. This is probably our best chance to get clarity. It's pretty clear that the SEC is not going to provide us with any clarity, and so we just need to get some congressional action, and I hope the bill passes. And once again, as was said earlier, please support it, because that's our best chance of getting regulatory clarity.
Yeah, I mean, I want to underscore that. We said it in the last panel, too. You know, we don't have that many chances. We have to actually take our chances. So if you have any questions about how to get involved and how to do something, then you should reach out to any of us, the panelists or me.
So we have only 30 seconds. Thank you very much to my panelists, and thank you to all of you for being here.